1 minute. Yes. So who can recap? Who can recap what we did last week? Any person that is moved with the spirit of law should recap what we did last week, like 2 minutes. Yes. Adele Abayomi. What did we do? What did we do last week? Don't recap anything that we did last week.
Sorry, sir, I was not in the class last week, sir.
Ah. Why? Why were you not in class?
I was sick, sir.
Oh, sorry.
Thank you, sir.
That's fine. Sorry. Who else do we go to now? Levi Kolajai. Anybody that was in the class? Is anybody that was in the class?
My Lord, sir. Good evening, sir.
Yes. Go ahead.
Okay, so last class, I think the lecture was about a contract. That we discussed a law of contracts. So, and I know you introduce what a contract is and what are the basic elements that we must find in any arrangement before it can be termed a contract, telling us that we must have an offer, acceptance, consideration, tension, and then the last one must be capacity. So you now explain each of those elements to us: the offer, what an offer is, the acceptance, what it means to refer to something as a acceptance, and you went ahead to differentiate between offer and invitation to a trade. And I think that's where we ended the class. Thank you, my Lord.
Thank you so much. Any other person?
Good evening, sir.
Yes.
Barrister here reporting for duty, sir.
Yes. Of counsel.
Yes, sir. My main key point of last class was the two cases we treated about a case of, though I cannot pronounce the name now, a case of where a newspaper advert was mistakenly placed, and after ordering different type of Toyota, the company later said that, oh, instead of 2.5 million, the newspaper house mistakenly published 1.5 million, and that led to one or two issue. And your question was not to us like, who should be at fault? Is it the company, the buyer, or the newspaper house? That's where we have to pick it up from today. And the second case we treated about if you buy this syrup, you will not contact flu. But after buying it, they still contact flu, and the lady sued them to court. Those were my key highlights of last class, sir. Thank you, sir.
Oh, thank you so much. Okay, so you don't have to waste time. Let's move to the discourse for today, which is on the second. Yes. So, oh, sorry, there's a hand up here. I saw a hand up here. Okay, Lucas have taken a hand down. Okay, thank you, Lucas. No more there. Um, so we are looking at elements of valid contracts. And what are those elements? Can someone just mention those elements of valid contracts? As we mentioned last week. But that's essentially what we're looking at now. Elements of valid contracts. Yes.
Good evening, sir.
Yes.
Good evening, sir. Good evening, fellow learned colleagues. So
Barrister who?
Barrister Vokes, sir.
Vokes, okay.
So, building on what Barrister Levi said earlier on, the elements of the contract, we have offer, acceptance, consideration, intention to create legal relation and valid capacity.
Great. So we've done with offered last week. So for those that I know were not in class last time, we're done with offer. So today we're looking at acceptance. Um, so just the way we're able to define as offer that time as being a definite expression, you know, a definite and clear, unambiguous expression or manifestation of intention. Acceptance also is defined in similar terms, and of course, someone should read that slide. Someone should read the first paragraph so that I will know we're all on the same page. Someone should read the first paragraph.
Acceptance. An acceptance is a final expression by the offeree that he agrees to the terms of the offer as conveyed to him by the offerer. Acceptance must be
No,
must
no,
be
no, that's fine.
unqualified.
That's fine. I said just the first paragraph. That's all. Now, so you see that the first thing there is to, just to explain that in very details as well. You could see that we're saying that acceptance is a final expression, final expression by the offeree. Remember, I would say that contract. Contract begins, between the offeror and the offeree. The offeror will make the offer, then the offeree will accept, and then you will say the terms of the offer, and then the contract will come into existence. So acceptance is, as I say, expression of, final expression, final, you know. And how do you know that? With the terms of the offer. You look at that definition very well. He agreed to the of an offer, as conveyed by him. So, and this is where the contract begins. You are not just expressing final consent, but that expression is in line with the terms of an offer. The offeror would have made those terms and accepting, you expressly agree with it. You consent. Um, this is where contract comes into existence. This is where contract begins. For every contract, you would say that there's a contract that's enforceable. There must be offer, and that offer must be accepted. The offer will contain its own terms of the offer. I give you an example that time of someone that you know admission letter at the university, or someone that wants to buy a car, for instance, or someone. So when you see the terms of the offer, you must express your own consent, in line with the terms of that offer. So if, for instance, now in trying to accept, you alter the terms of that offer, you accept partly, and you change some other terms of that offer, then that cannot be, because it's not final. It's not final, as the case may be. So it has to be final expression of the terms of. Now, you have to know that, just the way acceptance, you know, just the way we say that time that offer must be definite. So also, acceptance must be unqualified. It must correspond to all the terms on offer. So that's why it is a rule that what they call the mirror image rule. That acceptance must correspond to the terms. So no, in mirror, the way you have mirror in your room, or your houses, or mirror in your offices, even in the banks, there are mirror everywhere. Everywhere you go, mirror. Even that they put mirrors are everywhere. See, It's how you are that it will be reflected in the mirror. So, being who you are is the offer. But when you stand before the mirror, it's how you are, how you dress, how you appear that it will reflect it. So that's what the rule is, that the acceptance must mirror, the terms of an offer, and that's what they sometimes call the mirror image rule, which is that the offeree must accept exact terms of an offer without any intention to forget to bargain further. So, maybe the color was changed. Yes, I will supply you the car, but it's only black that I have. You see that it's not final anymore. It means that the person will not decide buying the black. There's some noise at the background. The class governor, let me make you admin so that I can control this class. Where is that? Where is the class governor? Where are you? The course
Come
rep.
on, sir. Come on.
Can you raise up your hand so that I can see you and add up as admin, co-admin? Where is the course rep? The class rep. Can I raise up your hand? Hello? Can someone hear me?
I've done that. I've done that. My hands
Class
up.
governor here. Okay, okay. Uh, Please, if you're not talking, you off your listen. So, the point I was making is that acceptance must mirror the exact terms of the offer, right? I'm going to give you an example of how you dress is how you appear in the mirror. It must be the exact terms, without any changes at all, right? So it's unconditional, as the case may be. So I tell you, look, where there's any qualification or any amendment to it, it will constitute a counter offer. So this takes us to what So if the rule is that acceptance must correspond with the terms of an offer, then what happens if that acceptance does not correspond? What will be the consequences? That takes us to what is called the invalid types of acceptance. And one of the invalid type of acceptance is what they call a counter offer. A counter offer, right? So the question is, what is a counter offer? A counter offer is any alteration, any change that is introduced by the offeree in the process of accepting the terms of an offer. Are we together? Are we together?
Yes, sir.
Are we together?
Yes, my lord.
Yes, my lord. Right on, sir.
Yes. Okay. So, so as I said, for the fact that a acceptance has to be exact, it has to be exact with the terms, correspond with the terms of an offer. So what happens if the acceptance is not, correspond with the terms of an offer? And I'm saying that takes us to new thing known as invalid types of acceptance. And one of them is a counter offer. And I'm trying to say that a counter offer is any alteration or any change, you know, by the offeree in accepting the terms of the offer. So where the offeree, instead of accepting the terms of the offer as this, introduce new changes to it. Now what we're saying is that will amount to what? Amount to a counter offer. So the question is, what is the effect of a counter offer? The effect of a counter offer is that it destroys the original offer. So if A has made an offer to B, now in B is supposed to accept for the contract to be valid, for acceptance, for contract to be valid. But if B, in accepting, introduce a term that was not contained in the offer, that new term that is introduced by B amounts to a counter offer. And the effect of that counter offer is that purported acceptance of B, which was saying is a counter offer, the effect of it is that it has destroyed that original offer made by A. such that that one will cease to exist in the eyes of law, such that it is B, what B is bringing on table, that now becomes a new offer. So the effect of a counter offer is that it destroyed the original offer. And then what's supposed to be in acceptance, or the purported acceptance, now become a new offer, which is left for for A, who was the offeror before, now the offeree, to accept or reject. So you see that one of the effects of a counter offer is that the parties would have swapped positions. If A is the offeror, he has made an offer to B. B is the offeree. Now B is supposed to accept that terms of offer as this. But if B introduces some changes, we're saying that they have swapped its position. The effect is that the offer made by A has been destroyed, and is the purported acceptance from B that will now become a new offer. So if the purported acceptance from B become a new offer, B is now the offer. Is no more the offer, no more the offer again because of these new changes. It's no more the offer again. It now becomes the offer. Now, who was initially the offer now becomes offeree, because what B is bringing on board is a new offer. And because the fact of the matter is that now something new, then it means that he also counter open counter offer open counter offer open counter offer open counter offer until the point that there's no counter offer and the express intention is clear and acceptance is made that parties are deemed to be consensus at idem. So you just know that if in the course of negotiation an offer was made, so assuming the University of Lagos, for instance, and admission letter was issued to you to pay school fees, XYZ as school fees. Now, instead of accepting the admission letter, still you say, oh, but you pay the school fees by installment. So if the term or the condition of installment was not in the admission offer, it means that your acceptance, proposed acceptance, have destroyed the admission letter that university have given to you. It means that it is your new one that becomes an offer. So University of Lagos will have the right to accept or reject. And if they keep quiet, if they did not accept, that means that you cannot even go back again, because once the offer is destroyed, the life of that offer would have come to an end once there's a counter offer. So you cannot even go back to it again. So you can see this in cases of Orient Bank and Milanta International, and those cases are there. You can even Google them online and see. And also you have, so that is just one of them. You have issues like conditional acceptance. You have those like cross offers and things like that. Now there's also what they call acceptance, subject to contract. If subject to contract, acceptance that is made subject to contract. Now, in some transactions, parties were accepted, but they will add a clause. That clause may be on top of the document. It may be in between. It may be at the end. But a clause will be somewhere saying that, oh, this agreement is subject to contract, and it's usually done in transactions like sale of land, inquiry. So if we're buying land, for instance, which we're supposed to make may require some funds to be given, for whatever reason, or for deposit for caution at time, offer for sale of the land, you must accept to buy the land at that time. But you say, oh, this is subject to contract. So when you say that something is subject, if that clause added to any agreement, you mean that the right of parties are suspended. The right of parties are suspended until a formal agreement is entered into between the parties. So you see that ideally, where a contract would have been effective once acceptance is made, because of that clause subject to contract, the effect of that validity of contract would have been suspended until that formal contract is entered into, before you can say that the two minds have come together, because you can say that there's consent or consensus at Eden, right? So then, of course, um, the point one is making here is that I mean, that takes us to another point which you need to also look at. In fact, if we read the case of UB and Tejumula, for instance, where the parties, this was a case involving a lease. UBA, somebody that are into the banking sector, it's a case that interests you, where UBA wanted to enter into lease it as part of their branch office, and but they say subject to contract. So, and then pays according to particular specifications. Change this one, change this one, change. So all the changes that were the UBA said that Tejumla should change, they carry all those changes. At the end of the day, UBA said that they're not going to lease that property again. So they have to sue them. You have to sue them. What do you allow us to make all these repairs, and then you say you're no more listening again, and things like that. So then they also added it's the clause subject to contract, and of course the court interpreted that widely in the case of you and Tejimola. So it's a case. One thing also, another rule regarding acceptance is whether silence amounts to acceptance. Whether silence amounts to acceptance. Right? And to answer this case, this a locus classical is a case of Faith House versus Binley. So Binley, yes, Binley, yes. So I'll give you 1 minute to go online.
And
At
we
what
can't hear
point?
you.
At what point were you disconnected? I just saw meeting disconnected. At what point?
The part where you said we should go online and check for something. We didn't hear that part.
At point what?
I said at the point where you said we need to go online and search for a case or something. We didn't hear that part.
Yes. Okay. So the case is, but is the slide still there?
No, we can't see your slides.
Can you see it now? Hello.
Yes, we can,
Can you
but
see the
we can't
slide
see the
now?
slides, but we can see your screen. We can see it now. Thank you.
So there's a case that I say that if you look at that slide, there's a case of Fed House case. Have you seen the case? That's the case I say you should just Google. I give you 2 minutes to Google it and let's discuss it. You know, there are sometimes that you make an offer to someone, this person is quiet, and then you assume that even though the person is quiet, the acceptance has been made. So this is what what we're looking at here. Are you seeing the case?
Yes, sir.
Okay, can we hear you?
Okay, good evening, sir.
Yes, introduce yourself and then
Yes.
let's hear your comment.
Okay, this is Barrister Ehi of the Barrister Ehi on the line, sir, of the
Yes.
SAN chambers, reporting the case of Fed House versus Bindley. In this case,
Yes, go ahead.
the court held that silence does not constitute acceptance of an offer. The case established that an
What
offer.
happened in the case?
Sorry?
What were the facts? What happened in the facts of the case? What happened in the case?
Okay, case summary is involve a dispute over the sale of a horse between an uncle, Fed House, and his nephew. Fed House offered to buy the horse from his nephew, stating, "If I hear no more about him, I consider the horse is mine." The nephew did not explicitly communicate his acceptance, but he did instruct his auctioneer, Bindley, not to sell the horse. However, Bindley mistakenly sold the horse at auction. Fed House sued Bindley for conversion, wrongful interference with property. The court decision ruled in favor of Bindley, holding that there was no contract between Fed House and his nephew for the sale of the horse. The court reasoned that the nephew's silence, even with the intention to accept, did not constitute acceptance. Acceptance must be communicated to the offeror. The court emphasized that an offeror cannot impose a contractual obligation on the offeree by stating that silence will be taken as acceptance. The key point of this case is that silence is not an acceptance. Communication of acceptance must be required in handwritten or in oral. Those are the key points here, sir. I rest my case, my lord.
Thank you so much. Thank you so much. Who is? Your counsel have made his own comment. Let's hear from one person, then we'll proceed. One person, just one person. Can we hear from just one person and proceed? Chairman, the class governor. Can we hear from you?
Okay, sir. So what I have here is I'll just give a brief case background. So the
Okay.
case involved an uncle, John Feldhouse, who negotiated with his nephew to buy a horse. The uncle claimed that he had reached an agreement on the price, but the nephew did not explicitly accept the offer in writing. So the nephew, however, instructed the defendant, which is Bindley, to execute the horse from a sale of his farm equipment. Despite this, Bentley accidentally sold the horse. So can I go ahead?
Yes, go ahead.
Okay, yeah. So the dispute was that Feldhouse sued Bindley for the conversion, which is wrongful interference with someone else's property, claiming that he had already acquired ownership of the horse through a contract with his nephew. And the court ruled against Feldhouse, determining that one, silence is not acceptance, which means that the nephew's silence or inaction did not constitute acceptance of the uncle's offer. Acceptance must be clearly communicated to the offerer. And two, acceptance must be communicated. For a contract to be formed, acceptance must be explicitly communicated to the person making the offer. Now, the significance of this case is that one, acceptance requires clear communication, which I said earlier, the contract which was formed here was not clearly communicated. And then silence or inaction is not enough to constitute acceptance. Hence, Feldhouse and Bentley remained a foundational case in contract law, emphasizing the importance of clear communication and forming agreements. Thank you.
Thank you so much. So you could see, so I expect while the two of them are reading that case, he also reads itself, but it's a locus classical to the effect that, So, but then always note that law always have two sides. Even though the rule is that silence does not amount to acceptance, there's a situation whereby, in the modern rules, there are sometimes it may be interpreted otherwise. So don't think that it may not, or it may always be the case like that. There's also the case of Folabi, Polymera Industries Limited, where you could see, as you could see there, you know. So someone should read that quotation there under the Folabi's case on the slide, so that I know you are all following. Someone should read that quotation there. Yes.
Please, please read, study carefully, and sign the duplicate copy attached, signifying your agreement to all points as listed above, and return at your earliest convenience for records.
So we could see that, and there was no evidence that the plaintiff ever returned the signed duplicate. He just kept it like that, and it was said that there was no acceptance. So that phrase that says you read is very familiar. With you businessmen. You always say, "Oh, sign the duplicate and return that copy." You never return. It may not be this message that you read might even be by way of email. It may be by way of SMS. It may be by way of WhatsApp chat and things like that. But just know that any transaction, any negotiation agreement involving or using internet gadgets is deemed to be in writing, by the Evidence Act 2011. So that's another example there. Now, there's what they call acceptance by post, the rule of acceptance by post. A post office. Nowadays, people don't use post office again, but in those days, everybody will have a post number. Like in Los Lagos, for example, they have a post office there around that bookshop, close to Eco Bank. The same building with Eco Bank there, there's a post office on top of that building where they accept letters and things like that. So what happened where you post your acceptance through a post office. So the rule here is that the contract comes into existence the moment the letter of acceptance is posted, and not when it is received by the offeror. So if, for instance, now the offer was made and acceptance was to be by post office. So if you post that letter today, if the letter is properly posted, that is it has valid address, you are paying the right stamp, it was done during the working hours and things like that. Once you hand over that letter to the post office at that counter, that moment acceptance has come into existence. Even though it may take 1 week before the offeror would have received that letter. So if within those days, the moment that this person posts that letter, the offeror is not aware of it, and they have gone ahead to deal with that subject matter with someone else, that will be a breach of contract, because in law, the contract comes into existence immediately it's posted, even though despite the fact that it has not been received by the offeror. That's why in business, most people, when they're going to agreement, they try to avoid the rule of acceptance by post because of that effect. Imagine that someone have accepted, you made an offer, someone have accepted and posted it. You are not aware of it. And the law is saying the moment that person posts, even though you are not aware of it, the contract has already come into existence. That anything you do contrary to it will amount to a breach of contracts. And as I say, this rule of acceptance by post or postal rule was established in the case of Adams and Lindsay. Here also, I'll give you like 2 minutes. Someone should Google this case because these are locus classical. These are cases that once you are doing law of contract, you must know them. Acceptance by post, Adams and Lindsay. Yes, who can give us 1 minute, 2 minutes? Someone should give us the facts of that case, and then we'll move on again.
Hello, sir. Hello,
Yes,
sir.
yes.
Please, while they are Googling, can I quickly ask a question, sir?
Yes, yes.
Okay. Sir, can we
Yes, yes,
consider
yes.
can we consider a gesture as an acceptance of an offer?
Consider what?
A gesture. Like, for example, if I shake my head, nodding it, does that mean that I've accepted the offer or without saying it verbally or written?
No, no, no. It depends on the one. The law has interpreted that as a matter of it can be yes, it can be no. And so there are instances where it was interpreted to be yes because just the way an offer can be made by conduct, acceptance can also be done by conduct. The way if you nod your head and you proceed with all action that shows that nodding is positive, then it will construe as such that is acceptance. So it's the accompanying action that follows the nodding of the head that determines whether that nodding or the head is a yes or it's no. So it has two ways of interpreting it. So it's a question of fact and circumstance. In some cases they head no, in some they say yes.
Hello, excuse me, sir. I have a question.
Yes, Adams and Lindsay. What happened in Adams and Lindsay?
Excuse me, sir, I have a question. Sorry
Go ahead,
to
go
take
ahead.
you back. In the case about Feldhouse versus Bindley, you mentioned in the last class that in auctioning, the hitting of the hammer, I think, signifies acceptance. But
That's the
the case,
general rule. They are also yes. Go on.
okay, but in the case of this Feldhouse versus Bindley, because if the horse was auctioned, that means he hit the I'm sure he hit the hammer, so that should signify acceptance of the auctioning also as well. I don't know, maybe anything.
No, that was not in contention. That was not the issue in contention. The issue in contention was that as at the time you were auctioning that hole, it already belonged to someone else. So they sued the auctioneer. They filed they sued the auctioneer and that for conversion. That the horse you are auctioning already was sold to someone else. And the question was whether that person had it in mind but did not manifest, really accepted the state of the horse. That was in contention. It wasn't about bringing the hammer down or things like that. No. The person was suing that at the time that you were ever doing that auction itself, the horse had already belonged to someone else. I don't know whether you understand the point now.
Yes, yes, I understand. Thank you.
Yes. Yes. So Adams versus Lindsay.
Adams versus
For
Listen.
Adam
Okay, go
versus
ahead.
Lindsay, because the case of Adams versus Lindsay is taught to university law students when studying offer and acceptance.
Yes,
It's
yes.
often taught by students to have set a rather strange precedent. However, this is because modern students are viewing Adams versus Lindsay in a modern context rather than the somewhat different context of previous times. This piece will explain the facts which occurred in Adams versus Lindsay and what the court decided. Facts in Adams versus Lindsay. The facts of Adams versus Lindsay are that the defendant wrote to the plaintiff on 2nd of September, offering to sell them some wool and requested that the plaintiff reply in course of post. The letter which contained the offer was wrongly addressed, and therefore the plaintiffs did not receive it until 5th of September. As a result of this delay, the letter of acceptance was not received until 9th of September by the defendant. And this was 2 days later than the defendants would have expected to receive it. Because of this, on 8th September, the defendant had sold the wool to a third person. The question for the court in Adams versus Lindsay was therefore whether a contract of sale had been entered into before 8th of September when the wool was sold to the third party. If the acceptance was effective when it arrived at the address or when the defendant saw it, then no contract would have been made, and the sale to the third party would amount to revocation of the offer. However, the court held that the offer had been accepted as soon as the letter had been posted. Thus, in Adams versus Lindsay, there was indeed a contract in existence before the sale of the wool to the third party, even though the letter had not actually been received by the defendant. The defendant was therefore liable in breach of contract.
Okay, thank you so much. That's Barrister who?
Dorcas, please.
Okay, thank you so much, Dorcas. So let's hear from one person, and then we'll move on. One person, one more person. Any other person that wants to try?
Yes, sir. This
Okay,
Barrister Levi Kalejari.
okay, go
So,
ahead. Just
case summary, Adams versus Linsell 1818, citation. Adams versus Linsell 1818, 1B and AID 681. Fact of the case, the defendant, Linsell, wrote a letter to the plaintiffs, Adams, on 2nd September, offering to sell wool at a specified price. They requested a reply in the course of post, which in those days meant a prompt reply sent via the post service. However, due to a mistake, the offer letter was misdirected and reached Adam on 5th September instead of earlier. Adams posted their acceptance on 5th September, the same day they received the offer. But due to delay caused by the initial misdirection, Lindsay did not receive the acceptance letter until 9th September. Meanwhile, believing that Adam had not accepted the offer, Lindsay sold the wool to a third party on the 8th September, legal issue. When the acceptance of an offer effective, is it upon posting or upon receipt? Heard decision. The court held that a binding contract was formed when the acceptance letter was posted, not when it was received. Thus, Lindsay was in breach of contract by selling the wool to another party after Adams had already posted their acceptance. Thank you.
What the rule is, and I will say further, I won't say anything further than that. Why that rule is so? Because if parties, want post office to be their agent, because the post office ideally, that letter that you are posting, you are supposed to deliver it yourself. So, but if you decide to use post office as an agent, then is the rule of agency also apply in there that the action of the agent bind the principal. So once they give a post office, it means that the post office is your agent, and that moment is binding because there's nothing that the offeree would have done after giving the letter to the agent of the offerer. So it's a common agent for both parties. And of course, if we insist that letters when you wait till they reach the offerer, then it will lead to delay in commercial transactions. So the court went ahead to make provision for all of those ones. And at the same time, there are also exceptions. Where if you look at that letter, their fact, they say that the letter was properly addressed. Wrongly addressed. So there are exceptions. For instance, uh, uh, you know, you know, where it will lead to injustice, where it's not properly stamped, and all of those ones, So there are scenarios, assuming that you have someone, your neighbor, and your neighbor is working with at the post office, and then you gave him a letter to go and post for you, and so the following day he has posted that letter for you. So now the question is that when was the letter posted? Is it when you give to your neighbor who's a post officer, or is when your neighbor actually submit it at the post office? When can we say it was posted?
When you
Yes,
give
when
it
can
to
we
your
say?
neighbor.
Eh?
At the point it was submitted at the post office.
Not when you give to your neighbor.
Yes, sir.
Okay, that's fine. So it's when is when you submit your. When it's properly submitted that it's not when you give to your neighbor. So you are correct in that regard. So it's all subject to. But because of the difficulties that this thing can create, you have to watch out in all negotiation between. That is involving you, so that if you don't want to get tangled with these rules of postal rule, just try to avoid it completely when you are going into transactions when you are negotiating transactions with parties. Right? Any question on that? That's all that you should note regarding the acceptance in that regard.
Question,
So we're
sir.
moving to the yes.
Sir, please, I just want to know if all these cases were tested at the highest court of the land, or is just first case, first court of the land? Because this
It's
last,
there now. You can see they are all tested at the highest court of land. They were all
because
these
this
are
last
almost
case
tested
is a
in
bit
England.
confusing.
So most of these here are from the House of Lords. They are not at cost of first instance. No. Any other question? Okay. The third element of contracts, which is consideration. Now, in every relationship, every transaction, parties will have to pay a price, and of course, uh, in contracts, there's what they call something of value in the eyes of law. You must exchange something for. You must pay a price to benefit from contract. Every contract. So even though you may have offer, you may have acceptance mirroring the terms of the offer. That itself will not make a contract enforceable unless you have to show proof that you have furnished consideration to the terms of that. You know, unless you can furnish that you say that you have furnished consideration to the terms of that. You know, offer, the contract, as the case may be. So you may call it the price, or you may call it something of value in the eyes of law. That is exchange between the offeror and the offeree. So all of them must furnish that. Now, if you look at the contract between the student and University of Lagos, for instance, there's everybody is paying a price. The student would have paid school fees, and so that school fees, before university will have the right to earn it, there's also an obligation on the side of university to do needful, which is why, 6 o'clock. We teach civil servant. They have closed. People that are working in government, they have closed their offices. They close office. Even the non-teaching staff. Some of them left before 4 o'clock. They left, but I'm here having lectures, and we're all in the same university, right? When the other staff they have closed, they left their home. They've gone home. They're sleeping. We are having lectures. When I'll be here till 8, and it's from MBA is from Tuesday. 2 days full time. Wednesday is for stream one. Thursday I will have another one again, 6 to 8. Friday again I have another class again, it's 6 to 8 and things like that. When other people are already enjoying at their houses. Why is it so? Because of the price that university have to pay, which I'm doing this on behalf of the university. So, and that's why the university can conveniently say, okay, do this, pay this school fees. Otherwise, they can't have any justification of keeping you right, keeping your money. So for every contract, you must show. So students too must always show that they pay a price. That's why the certification will be given to them and things like. So every transaction, if you go to any superstore, two things happen, right? You have to you know, deny your money. You need to give out your money to take item from the superstore, that store, that shop that you want to shop items. So the items belong to the owner of the shop. The money belongs to you. But if you want the items, you must furnish something in return to keep the item. Then, of course, the owners of the shop also must furnish the item to take money from you. So, for every contract, every relationship, a price has to be paid. And then, of course, that's in the case of Korea and Misa, the court define, consideration as, yeah, someone should read that first paragraph. Someone should read it. Someone should read it. The first paragraph.
Consideration is the price which one party pays for the promise or act of another.
Yes.
Consideration consists of some rights, interest, profit, or benefit accruing to one party, or some forbearance, detriment loss, or responsibility given, suffered or undertaken by the other,
Thank you so
Sikora
much.
and versus Mr.
Thank you so much. Exactly. So you see that the way they define it, like also it is right, interest, profit, or benefit on one hand, and then it could also be a detriment, a responsibility given or suffered, undertaken, as the case may be. So so there are many services. For instance, if it's for instance you hire someone to, there's always the two are always there. You know, you purchase item from contract for the sale of a house, or you want to rent a shop for your business, or rent an office for your business. You know, you would have suffered. The money that if you have 1 million, or have 100 million, and you use 50 million to rent that property, you are your worth has withdrawn. You have lost your worth from 100 million to 50 million. But you also gain something. You have gained, now you have interest in the property which you have leased. So it could be a benefit. It could also be a detriment that you have suffered. you know a price that you are paid, in that regard. So it is not only positive, it can also be negative, but at least you are doing that because of the contract, because of the agreement that you have with the other party. So you must furnish that before a contract comes to this, not just offer and acceptance. But of course, when you have offer and acceptance, the law will still insist what price have you paid after that, right? So even the staff, you have of employment work, employment contract, for instance. So you have letter of appointment appointing you to work, and then you accept the employment, and then you sit at home, and then after 30 days you go to that office that is you pay you salary. You see that they will not be accepted, because it's beyond just offer and acceptance. You still have to pay a price that will ask you. So after they gave you an appointment letter, and you accepted appointment letter, what else do you do? You went home, you went and gave Thanksgiving, and be sleeping at home for 30 days. You can't get the money, you can't get the salary. Why? Because you didn't pay a price, you didn't suffer the detriment. So that is just what we're saying here, that in every contract, the other party must show all of those things. And then you can see some of the rules of it now. Because the same consideration was moved from the promisee. The promisee is just the same thing as the offeree. So if you are the one that made that promise to enter, so if your promise was to, you do XYZ, you pay school fees and all those ones, you must actually pay it. And of course, so if you are claiming that the university have breached its contract, and they ask the question that, when you made a promise, what do you do? Oh yes, I paid my own. I paid the school fees. University is the one that did not perform its own part of the obligation. The same thing with the lease of property. The same thing with the sale of goods. The same with shopping. The same. There are many of those things there. But anything that has to do with contracts, the other party must show that. The party complaining must show that is the one that he has furnished consideration as on his own part, because a contract is just an exchange of promises. You exchange promises, as the case may be. It must be of real value in the eyes of law, not in the eyes of men. Something that has to do in the real value. Value is the law that determines that. If monetary value, but it's something that has value, that can be measured, as the case may be. It need not be adequate. It need not be adequate. So that's what the law did not bother about. If, for instance, now we in Banana Island or in Lekki or BI, or where the property that is worth maybe 500 million, you decide to sell it in the contract of lease. In the commercial sense, that is not the value of that property, because the property is worth 500 million. That is the market value. But you may decide to sell it for coercion. Once nobody, there's no evidence that someone forced you to sell it at that. The law is not bothered about the fact that, oh no, you must sell it at the going rate of that property. No. If you want to give it out at 1 naira, fine. If to you that 1 naira is sufficient for you, fine. The law is not bothered about that, except in cases whereby, So even though it's not adequate, it must be what? Sufficient. Sufficient in the sense that that is exactly what the other party wants. So There are also cases here, and then also we have the case. The another rule is that consideration must not be passed. In other words, past consideration is not a good consideration. Now, this case of Kenzwa to the Oba of Benin, and so what I mean is that that promise or that action, that which is undertaken on contract, they must go together. If for instance now you have carried out an act before seeking compensation, that cannot be a consideration. So assuming for instance now you maybe a UCOPA, for example, some people that have done you service in a particular organization, after you service, they are expecting that maybe the organization will employ them. They have not seen letter of employment, but they are working. They are working in that place. Maybe they work for 6 months, no letter of employment. Now the letter of employment has come. Now for those 6 months that they working, no salary was paid to them. No salary was paid to them. But now the employment has come. Now the employment has come. Excluding those 6 months. So you see that even though you have letter of employment 6 months after, you cannot claim the 6 month salary arrears because of what you have done in the past. Because you are not doing those working for those 6 months because of the new appointment letter that you got. So that's why I'm saying that it must not be passed. It must not be based on something you have done before. Why the agreement is entered subsequently? No, it must be furnished based on the agreement itself. So if you have done an act or if you have suffered a detriment separately in the past, and then subsequently there's an agreement to that effect, you cannot backdate it to say that, oh, if what was done in the past should also be extended to what you know. So generally speaking, consideration must not be passed. So if you look at the case of about Benin, for instance, this was Benin Divisional Council, a case involving those of you from Benin, you should know about Oba of Benin, where the forest, they had tuber, all these economic trees, forest, and the white men were cutting it and selling it away. So they took over the place, and then they had the Oba, had, they had a council and the council meeting and they complained to Oba. So Oba promised them, I will use my influence to take this forest away from the foreigners. So he actually used his own influence, recovered the forest from the foreigners, and gave to his own people in Benin. In Benin. So at the meeting, they were very happy. They were very happy for what he has done. So they promised that they will give him part of the forest, for as appreciation of what he has done. When he wanted to take over the part of the forest as agreed, the council for the promise that they made that they will give him a half of the forest in appreciation. So the question was that at the time that he was negotiating to take over, at the time that he took over the forest from the white men, did the council promise him that they will give him the half of the forest, and that was why he was engaging. That was why he engaged the white men to take over the forest, or no statement like that, no promise like that was made to him. Could see that because that promise was not made to him at the time that he was doing that act of taking over the forest, but it was subsequently. It means that what he has done was in the past, and then the promise to compensate him was the subsequent, and it wasn't a valid consideration, and that was how he lost the case. So, whatever detriment that you are giving as consideration must be as a result of a existing contract. It not be something that you are doing in the past and then you want to use subsequent contract to also cover the one in the past. So you have to take note of all of some of these things in the when you are negotiating, as businessmen. Now, there's what they call promissory estoppel. We are saying that yes, the one of the rule of consideration is that um, it it need not be adequate; it has to be sufficient. Now, the question is whether payment of lesser sum will discharge the obligation to payment of a greater sum in that regard. So what they're saying here is that where you have a contract for payment of debts, you owe someone that you are supposed to pay that person debt. I don't know whether you have experienced this before. You are owing somebody, and then maybe that person is to pay you. Maybe assuming that someone has borrowed money from Choma and is to pay that person is to pay Choma in 6 months' time. Now, 2 months after, still within those 6 months, 2 months after, within those 6 months, Choma now requested for, give me the money. Oh. Anything, go, I need money now. Give my money back. He said, no, it's 6 months. I can't get this one now. He said, okay, you know what? Just give me whatever you have, and I'll forget about the balance at all. Now, that person has given Choma half of the money based on the promise that Choma has said, I will not go back to the full balance. Now, but after that, after 6 months, Choma has gone back again to get that look, oh, you know what? You must pay me the balance. So the question is whether that payment, that small, that lesser amount that this person squeeze and pay you is enough consideration for not paying the balance that's remaining. In other words, can someone be stopped? Can someone be stopped from not going back to his words? These are the things that this is what this promises Esther Bureau is talking about here. So, generally speaking, payment of lesser sum cannot discharge the original obligation. Otherwise, you have to pay all. But there are exceptions. These are the exceptions. One of which is the promissory estoppel. Where you promise someone, the person rely on that promise to change his own position. Then you cannot go. You are not allowed to go back your own words. So, if the debt was repaid in 6 months, and you
Oh, we can't hear you, sir, if you're speaking.
property limited was a high risk case, which was about rent of apartments. There are all these cases in that regard. And then, of course, we have this one, accord and satisfaction. Also, another exception, where you pay a lesser sum, that, to the satisfaction of the debtor, that new sum is a code, is an agreement, of course, which is binding on the other party. You can't go back again to it and all of those ones. So these are the exceptions to the rule: introduction of new term, promissory estoppel, composition, and then where there's accord and satisfaction. So these are penal cases there are cases that you need to read. Very interesting cases. Penal case, very interesting cases that you need to read in that regard. Any question on this? Hello.
Question, sir.
Yes.
Sir, this
But I say
last
he.
yes,
Other
sir.
people are in the class. So if people allow only he. People are saying he's the representative. He's the only
No,
thing that
sir.
is speaking.
I'm the dullest in the class, so I always want to learn.
Okay. Okay.
Yes.
I
So,
can't take that to bank. I cannot take that to bank anyway.
sir, my question is on this last example you cited
Yes.
about Choma asking, just give me anything, and later coming back to demand for more.
Yes.
In that case, what's the like the judgment? Is
No, I'm
Choma
saying that is where that is the case. Where because I know that this person would not have stressed himself to pay the money within 2 months. He would have waited till 6 months. Now, that's what I'm saying, that it comes under estope, also accord and satisfaction, in the sense that because that person have changed the situation, it is a change in circumstances that he would have gone through. Stress himself to look for money and pay this money within the shortest time outside the terms of the agreement. So that alone, that suffering alone is sufficient for Chioma not to go back to request for the balance. That's what we're saying. But if you go to the general rule, the general rule is that Chioma can still ask for the balance, but there are exceptions. There are exceptions whereby you cannot ask for the balance, and those are the exceptions that I mentioned in the where there's a new term, where there's promissory estoppel, according to satisfaction and composition, where you restructure the debts. You can't go back again.
I have a
So when you
question.
are yes, Barrister
So,
who?
sir,
Now the
Barrister
class is
Anastasia.
now the class is talking. Class is coming up now. I was worried.
Okay, sir. So,
Eh,
in a situation where the person that borrowed someone else's money, let's say it was a written agreement initially that okay, in 6 months you're going to pay me back. In 6 months you're going to pay me back, and then when the person is coming back to this person to say, you know what, just give me some money, maybe around that 2 months, then you forget about the rest, and it is not documented. If this case goes to court and the other person says no, this is not how it happened, will you still be in favor of the person that was lended the money?
no, if alleging was proved, that's one thing. So if the person is alleging that that's what you might inform her orally, they must prove,
Yes.
because you can also prove. If you cannot prove, then you have to go back and pay the balance. Because the rule is that
Okay.
if he who alleges must prove.
Okay. Okay. Thank you, sir.
Yes. Any other question? Okay, let's go to. Let me see the chat here. He's breaking from. He has gone off again. Where is he reading from? People are asking for things online. So he down adapting. Where are you reading from? You do have another material that they don't have. Okay, I can see all the chat there. All right, tenants please, blah blah blah. Okay, tenants link, guys. Okay, Chuma is working on the background. That's great. So where is my one tenants link? Now wow, Chuma. Now, wow. Okay, so let's go to the another element of contract, which is intention to create legal relationship, right?
Sir, we can't see
Now,
your screen again, sir.
ah, can you see now?
Yes, we can. We can
Yes,
see
sir.
them.
Okay. So intention to create legal relationship as another term of, as another, you know, the intention to create legal relationship as another element of valid contracts. Now, as I said at the beginning of lectures, I mean the first week that we had interaction, I said that look, in law generally speaking, intention is what you have in mind, and no one knows what goes on in someone's mind. No, no, there's no superhuman that can know what goes on in someone's mind. So, there are some students. I used to tell students that look, there are some people in class. No matter how you want to teach, they made up the mind that they don't want to pass your course. They're not eager to graduate. So they already plan themselves that look, as I'm here like this, I must spend 4 years here. So whether you teach, whatever you do, they will not do. They don't tell you this is what I have in mind. That's by the way. So because it's difficult to know what goes on in someone's mind, but then that intention is also a requirement of contract. How do you not know? How do you not determine intention? Determined by way of presumption. By way of presumption. You know. So that's why the issue that the paragraph is saying there that whether the law will presume the intention to enter into is it depends on the circumstances of each case. Now, but to achieve this presumption, the law now divide contracts into three categories: social and domestic agreement, commercial agreement, and intermediate situation. Right. So in social agreements, you know, uh, between husband and wife and all of those ones, the law presumes that there's no intention to enter into a binding legal relationship. So what I mean is that, between husband and wife, if they're legally married, and they're promising themselves, honey, I promise you, honey, I promise you, in the eyes of law, that promise that is a husband is making to husband or what, they are not enforceable. They're just playing love. And love, they shake their head. Nothing. So that's why you always say that, oh, my wife promised me this on my bill, or my husband promised me car on this. He promised you car, but he didn't buy. There's no binding agreement. So you don't know. So I hope they are not married people on this class. I hope you're not at home. Don't start fight. But that's the truth. That's what. So when the husband is promising you, in the eyes of law, you know what? Nothing is binding. You know, because just domestic agreement. Or when the parents are busy promising their children, go back to school. I will send this one to you. They didn't send. You can't sue them. Nothing's binding. They're all domestic agreement. And of course, you could see the case of Bafo and Bafo, married and married. You can read one of someone can should start read Bafo and Bafo. Husband and wife. When you see a case that has similar name, back to this same name as this name means that it was a family, it was husband and wife that were involved. That's how they cite them. Once see the same name means that it was husband and wife, the same name. So if it is Levi now, you see Levi versus Levi. It means that Levi and you know that it's now husband and wife will have they quote. They don't feel to themselves. That's why the matter enter quote. So who is reading Bafo and Bafo? Another person may read merit and merit.
Okay. Buffer and buffer. Okay, it's safe to cover.
Yes, go on.
Okay, buffer and buffer 2 KB 571 is a landmark English contract law case that established a presumption against the creation of legally enforceable agreements in domestic settings, specifically between spouses. The court held that agreements made between a husband and wife, especially when living in amity, are generally not intended to be legally binding contracts. Case fact: in Balfour versus Balfour, a husband, Mr. Balfour, who worked in Ceylon, now Sri Lanka, promised his wife, Mrs. Balfour, £30 per month as maintenance while she remained in England due to health issues. The couple was initially living together in amity, but later separated, and the husband stopped making the payments. The wife sued to enforce the agreement. Court decision. The Court of Appeal ruled in favor of the husband, holding that the agreement was not a legally binding contract. The court reasoned that agreements between spouses, especially when made while living together, are typically not intended to be legally enforceable. The court
Yeah.
emphasized that such agreements are often based on mutual affection and trust rather than a deliberate intention to create legal obligations.
Hmm.
Key legal principles.
Yeah. No, it's okay. So you will hear it yourself. No, so when they're being promising, it's just love and affection that is playing there. That is what the law is looking at you. That's why it's not good to practice law at home. And just even if you're at home and having these lectures, please, don't take it serious. So that's what the law is. Take that say you are not at home. Don't take law into house and start looking whatever the husband will promise you. Said this man in the eyes of law, you are just not serious because please, I'm begging you, learned colleagues. I hope you are hearing me very well. Don't carry and go inside house. Don't carry law enter house or the thing will scatter. Yeah, I don't want to make house scatter. Let's do law outside the family. So in commercial agreement, the law presumes otherwise. That's why in commercial agreement, the presumption is that parties intend to create legal relationship and make a marriage contract, even though it may also be revoted. You know, there are some agreement that will say, a commercial agreement that will say that this agreement are in honor only. People that are doing bet Niger, all this bet Niger that if you play this one, you win. If Chelsea win this one, you get this money, this and that. I don't. Some of them don't even read the terms of that betting. There's a clause in the betting game that says the agreement is in honor only. What I mean is that if you win that 100 million, they say they don't have, you can't sue them, even though it's a commercial setting. You know, so for all commercial dealing, all commercial transactions, where there's issue of monetary exchange. So even between our husband and wives, I said, if the wife has a shop in the this place at Lagos Island, where you buy a demeter, what they call it, where you buy things and sell. That's a shop there, and the husband has gone down to pick item in that shop. The husband will pay. Oh, nothing like you are my wife. We're staying together. No, that one cannot work because it's a commercial setting, right? So, as I said, there are also situation whereby there's a clause expressly excluding the intention to enter legal relationship, like football pool, all these ones, as I said. You know, even collective agreement also agreement between employment relationship where you have collective between trade union and the management of a company. Where there's collective agreement is not binding until that terms of that collective agreement is integrated in the terms of the, I mean, in the condition of service of the company. That is one where it will binding on the parties. So in intermediate situation where the law also look at it where it is in between social and domestic agreement, the question is also a question of fact and circumstances itself. The general rule is that there will not be intention, but if the court interprets otherwise, there will be intention. So in all of this, as I said, the law only it's only presumption, because the law, there's no human superhuman that will know what goes on. So if someone is in the course of negotiating the contract, people are exchanging promises in the contract, either orally or in writing. you know the law only apply the presumptions, because someone may write something down, may say, oh, fine, fine, fine things. Even a pastor, someone will dress looking fine, but what you can never know what goes in the mind of that person. Never. you know so they are all presumptions, open presumptions, and open presumptions. Right. Any question on this? So the last element is valid contract because of time. The last one is issue of capacity. So the general rule is that every person have the valid capacity to enter into a contract. Every person. That is what the general rule says. That everyone has the capacity to enter into a valid contract. You know, but there are exceptions. There are exceptions to issue of capacity. You know, and these exceptions are meant to protect certain parties to contracts, like infants, like oppression, like insane persons, like illiterates, you know. Like, so for illiterate, for instance, a contract entered into, who is an illiterate? An illiterate is someone that did not understand, cannot read and write in the language of the contract. So if for a professor of English, of professor of French, you don't know, you can't read and write in English language, and the contract is written in English language, then you are an illiterate in that regard. Or if you can read and write in English language, but you can't read and write in Latin language, and the contract is in Latin, you are the illiterates in that regard. So, someone that cannot read and write in the language of the contract is an illiterate. So the law now says there's illiterate protection law of each state. Like Lagos State, for instance, you have illiterate protection law of Lagos State. Now that law make provision for the requirements that must be met before a contract is binding on an illiterate. And one of the requirements is that it must be signed in the presence of uh, you know a attorney, and there must be a cover, like an oath saying that the person who that on behalf of the illiterate read all the contents of that agreement to the illiterate. The illiterate, understood to the satisfaction before the contract was entered into, and then you stamp and seal it. So if you don't have this requirement made as stipulated in law, that agreement cannot be binding on the part on the illiterate because of lack of capacity. Now, for a child, a child is someone, and for purpose of contract, a child is someone that is less than 18 years old. Now, for a child, it depends on whether it is a contract of necessary or contract of non-necessary. So a necessary is something that is of value, something that is important to the life of a child. You know, so like apprenticeship, for instance, these are all necessary, or provisions that will require the student to go to school and things like that. Are all necessaries. But it also varies. If a child is from a rich family, and you also have is a factor. If a child is from a poor family, it's also a factor. So, and there was a case whereby someone supply a child that's from a poor family was someone now supplied that child with milk, egg, bread, egg, milk, and things like that. How can a poor son of a poor person give me all those ones? Why do you want till the parent can use the money and pay? It's a waste of time. But for rich ones, and then if the child have those ones, already have those things in excess, and you are still supplying, you're also wasting the time. So it must be something that is necessary in the life of that child. You know, those that the child would need in life to grow, to nurture the skill, and all of those ones. Those are the things that the child would need. These are things that are necessary. Anything outside of that, luxury cars, luxury clothes, expensive jewelries for a child, you are wasting your time because they are non-necessaries. They are not binding on the child. Of course, and the child also they have discretion that after crossing the age of 16, they can ratify the contract as if they were age of that time. Mad people, mad people also can go into contract. Hello, who can give me how who can explain to me how a mad person can go into contract? Someone that is mad. Any explanation from someone from the floor of the class?
Good evening, sir. Yeah, so a mad person can
Yes.
enter contract when the person is at the lucid interval, maybe when the person has a moment of sanity, the person can enter into a contract.
Great, exactly. There are some madness that are seasonal. So madness come and go. They will some people are mad those season. So when the madness come and go, at that sanity time, losing towers, you can go into into a violent contract and it's binding, even though it's a mad, you know. But then the question is how do you know that someone is mad? Dedako, how do you know that someone is mad? I did that, but you are the one that gave me the answer now. You are right. So how do you know that someone is mad? In Lagos, we were mad. All the drivers say you are mad, you two are mad, you two are mad. After they hit each other, all these car owners, do you know who I am? You are a mad person. You two are a mad person. You two are a mad person. Uh-huh. Yeah. So someone is saying that in Lagos, everybody is a mad. Everybody is mad. Yeah. So Grace, you are one saying that everybody in Lagos is mad, Abi. Uh-huh. So how do you know
Yes,
that someone is mad? How do you know that someone is mad?
because how can somebody wake up as early as 5 a.m. and the person has started cursing along the road? That's madness now.
Well, I think for Lagos, so Grace, no, well, me, I'm not. Oh. Me, I'm not mad. Oh. Ah, you ever include yourself? Say everybody in Lagos. Now, but the issue is that in Lagos is It's what they call lunacy law of Lagos State. There's a law of madness in Lagos State. Maybe you are not aware of it. So that law now stipulates on how to determine that someone is mad or a normal person. You are not seeing the law before. So
No, sir.
so madness is just not by calling you are mad. Because someone say you are mad, then you are angry. You are angry. No, that person looking at you cannot say you are mad because the law already make a provision on how to determine that the criteria for determine that someone is mad or not. So it's only when you are tested and certified mad that you are a mad person. So that's by the way. I just want to let you know. But I'm glad to know that Grace has educated us that look Omo in Lagos, Namado. Okay. Now, lastly, for the company, they also have the issue of capacity. The company, as I said earlier, that was last week, that a company, when you are incorporating a company, there's what they call the object clause. In the object clause, it contains the purpose for which the company is created. University of Lagos, for instance, is also a company created by legislation, the University of Lagos Act of 1962. So that legislation, if you look into that law, it states what are the powers of University of Lagos. And that's why you cannot see University of Lagos constructing bridges across lagoon, even though it's by lagoon. You can't see it doing that because the powers of the object of University of Lagos is not to construct like bridges or construct roads, as the case may be. Even when there's a bad road in University of Lagos, they go and hire contractors to come and repair the roads. They won't do it themselves, as the case may be, because they're not road contractors. So you can banks, you see, these are financial institutions, insurance companies, they're all financial institutions. So you cannot see a bank say that UBA is the awarded contract to construct the fourth mainland bridge. You can't hear that. Why? Because the object clause of the Zenith Bank or UBA did not include construction of bridges. They're not. So if UBA want to go into construction, they will have to go and create a subsidiary company, and mention the object in that subsidiary company, saying, "Oh, this company is for doing that," and that's why you can see that many of recent people are hailing Tony Olumolu for expanding investment to health sector. He built very massive hospital in land in Sulele also. Who are those posted in Sulele? Is it true that the UBA guy has that was far into the hospitality and the health sector? Who are those people in the UBA? Yes, let's hear you. Let's hear the experience.
He hasn't, but his wife owns the hospital.
Okay, the wife holds the. So who founded the? Okay, the wife is also one of the what do you call it, directors in UBA, I guess. Yes, so something. Yeah. So you see that they can't do that no matter how they can't do that on their own. They have to incorporate a new company. That's usually where the capacity comes in. So even the company that you are working on, try and find out, those that are working or those that work, just find out the capacity. If you don't have the memorandum of your company, go and find out quietly because if you ask them for it anyhow, they will suspect you. Why are you asking for the memorandum of this company? They will suspect you. Find out from HR or somewhere where the records are kept, so that if you in the memorandum of the company, you go to the object clause, you see the powers of the company you are working with, so that if they give you any assignment that is outside the powers of the company, you are acting beyond your powers, and that's what they call in Latin ultra-virus, beyond powers. So the law is that you must have valid capacity before you enter into a valid contract. If you are signing as a company, you are signing a contract, and the memorandum of the company did not allow you to go into that kind of contract, you are wasting your time. I give you an example of a company, a pharmacy, a pharmacist. There was a pharmacy that they have this person. They wanted to diversify into hospital. So to do that, in their memorandum was they don't have hospital management or employing doctors in their memorandum. Now, but they want to expand. They have not done that. But they now train one of their staff to become medical doctor. They trained that guy abroad. They trained the guy abroad. When the guy came back to Nigeria, he was after being a qualified doctor abroad, came back to Nigeria and resigned. That he can't work with these guys. He's above them. It's not you that he will train you for a purpose. And So the chemist now sued the guy. He said, "No, you can't. Where is the memorandum? You don't have any. There's nowhere in your memorandum that said that you should train a medical doctor and hire a medical to work for you and all of those things." And behold, they opened the memorandum. There was nothing like that in the as the powers of that pharmacy company. It means that training that they did to the medical to make that guy become a medical doctor was beyond their powers, and the guy was not bound to do what to work with them, and the guy left. So it's not as members go in business, whoever you are going into a business with, find out whether the person has the authority, whether he has the capacity before you start negotiating with that person. Very important. Otherwise, what to be doing will be a waste of time. Imagine you negotiate with another company for a whole year, and then you just suddenly discover that, oh, that company don't have the power to go into that transaction in the first instance. That means you are wasting your time. You are negotiating with someone and that person don't have the authority or consent. You are wasting your time. So you have to verify all of these things you even start negotiating with any partner or any company that come your way in the course of carrying on your various businesses and transactions. So, ladies and gentlemen, this is where we stop for today. Questions? This is where we'll stop for today. Yes. You guys have gone for your dinner, Abby. Everybody having his own dinner now. It's quiet. No more talking.
Thank you for the class, sir.
Thank you, sir, for the class. Thank you so much.
Thank you for the class.
I know you will thank me. Olajumoke, you will thank me because you are having your dinner now. Me, I'm seeing the office. You are having your dinner. No,
sir, I had my lectures in transit. Sir, my lecture was. I've not had. I was doing transit. I was receiving your lectures.
Some of us are in the office.
This is life no balance.
Some of us receive your lectures in transit.
Now, wow. So we are in together. Me, I'm seeing the office.
Thank you so much, sir.
All right. So,
thank you.
By God's grace, yes, by His grace next week. Yes, thank you.
Sorry, please, can we get the slides?
The governor is asking for slides.
Yes, so I don't have it.
We don't have it, sir.
Her Excellency, you mean we don't have it?
Yes, we do.
Okay, we'll do something about it, right?
Okay, thank you so much, sir.
Thank you very much, sir.
Welcome, my colleagues.
Thank you,
Yes, sir. Permission to move a motion for adjournment of the class.
Thank you.
Thank you, my lord.
Thank you, my colleagues, learned colleagues. Thank you, learned colleagues. I learned a lot from you.
Our lord.
I learned a lot from you.
I, Barrister Ehi of the Ehi Chambers, move a motion that this class be adjourned to next week, same time, same radio station, and same venue. I so move, my lord.
Yes, the motion granted.
No be radio station, I court, so you say na radio station.
Oh my God.
All right. Good
I
night,
love
sir.
you guys.